Good morning, everyone, and welcome to our today's webinar, Insights on the German Supply Chain Act. A few housekeeping items. First, everyone but speakers are muted at this time. Then this meeting is being recorded and we will share it with you after the session. There will be a survey at the end of this webinar for you to fill in. In order to receive a copy of this webinar and also some additional documents if any. If you have any questions or comments, please use the comment section. We will get back to you at the end of the webinar or we will follow up with you after the session. Today's speaker, Sri, our head regulatory compliance. Over to Sri.
Thank you, Pavitra. So our company is API Engineering. Just give a quick glance about API. API is a 21 years old company. We are a global company. We are ISO 9001 certified, and for the processes, and we are 27001 certified for the information security practices. We also have the TISAX stamp, and that is the stringent norms for the automotive information security practices when we are working with the German clients. We have a number of clients across the globe. As a company, we have 4 verticals. One is compliance, so which we deal with the product chemical compliance is our key strength. And we have engineering. We help customers in managing, developing the product development process using several CAD/CAM software. We have the sourcing facility where we source the components for our customers from best cost countries and ship it across to different parts of the world. We also have a software services division which helps customers in creating the custom software. We also have software on our brand too. So through our in-house software development team, we have also developed a compliance software which handles several regulations. We also have services to handle all these compliance regulations. We provide the turnkey solutions so it is right from start to end. Next slide. Time for a quick poll. Kindly choose the appropriate option. Thank you. So today's agenda is fundamentally we'll speak on German Supply Chain Due Diligence Act. So the agenda is we'll quickly go through how was the regulation evolved, what is the background, and what are the different sections in the regulations, and similar do we have any similar regulations across the globe, and what is the comparison matrix. We'll go through that, and the growing importance of ESG, that is environmental social governance. And lastly, we also go to the practical implementation and followed by a recap. Next slide. So before we speak about the German Supply Chain Due Diligence Act, let's talk about how it was evolved. What are the guiding documents or inspirations for this new German regulation? In 2011, United Nations has published the United Nations Guiding Principles on Businesses and Human Rights, that is called UNGPS in short, which was the product of decades of effort to create the global human rights standards for the enterprises or the companies. This is the Bible for all the modern regulations, and the UNGPS is a guideline that consists of 31 principles implementing the United Nations protect, respect, and remedy framework. The standard was drafted based on 3 main objectives on how states and businesses should implement the framework. Those are fundamentally, the states have the duty to protect the human rights, the corporate responsibility to respect the human rights, and access to remedy for the victims of business related abuses if these rights are not respected. Next slide. In the same year 2011, while UNGPS is a standard that was published in 2011, in the same year the independent organization OECD, which we are aware of it, has published a document called OECD Guidelines for Multinational Enterprises that has drafted the guidelines and recommendations for multinational companies. These OECD guidelines provide the non-binding principles and standards for responsible business conduct in the global context. And OECD also has published another document that is called OECD Due Diligence Guidance for Responsible Business Conduct. The current version is 2018. This document provides practical support to companies on the implementation of OECD guidelines for multinational companies. For both in order to access both the documents, we have provided the link at the bottom. Next slide. After 2011, the major implementation happened in 2017. That was especially in the European Union context. Uh, the first country to implement a human rights violation or supply chain due diligence regulation for corporates is France. So it implemented a regulation which was effective from 27th March 2017, 5 years old regulation. This regulation is also called as France Duty of Vigilance Law. This law applies to the French companies with more than 5,000 employees in the company's direct or indirect French-based subsidiaries, and with more than 10,000 companies if including the direct and indirect subsidiaries globally. So there are approximately 150 companies which are falling under the scope as per the law, and a vigilance plan must provide as per the law. A vigilance plan must be provided that includes corporate due diligence plan and identify and analyze the risks of human rights violation or environmental norms, actions to mitigate the risks which are identified, mechanisms to assess measures that have been implemented, and there is an obligation of annual reports to the public. Even though it is a 5 years old regulation, there are certain questions that are remained with respect to the scope of this regulation. Indeed, it remains unclear whether it refers exclusively exclusively to the first year of a supply chain or its additional tiers for further along the chain. In addition, there are no implementation decrees or clear legal definitions provided in the law, so that made it not so popular. Next slide. So now we are coming to the crux of the regulation. So taking the inspiration from UNGPs and the French law, Germany has implemented the new Supply Chain Due Diligence Act. So essentially, the German law has got, if you look at the literature, it has got 24 sections in total. However, the first 10 sections talk about the requirements on how to handle this particular regulation. We shall cover major requirements and all these 10 sections in the subsequent slides of the webinar. So it was published in the German language initially, and an English translated version was also made available by the government subsequently. We have provided both the links in the presentation for your quick reference in the below. So coming to the section 1, which is which talks about scoping and implementation date. The Supply Chain Due Diligence Act, or short in short, it is also called as LKSG, which is in a shorter form of the legislation title in Germany, which was adopted on 11th June 2021. For the first time in the history, the law included a binding obligation on companies to establish, implement, and update the due diligence procedures to improve compliance with the specific core human rights and to a limited extent environmental protection in the supply chain. So as said, the law will come into the force from 1st January 2023, 8 months from now. The scope has got two types of companies based on the employee strength. From 1st Jan 2023, companies which are having the central administration or headquarters or registered office in the Germany, provided they have more than 3,000 employees in Germany. On 1st January 2024 onwards, the threshold will be reduced from 3,000 to 1,000 employees. So from an independent survey, it is estimated that the number of companies exposed to this regulation would be around 900 in 2023 and approximately 4,800 in 2024. Next slide. Unlike the French Vigilance Act, where there are no clear definitions on what is meant by violation, here in German regulation, they have given the clear definitions on what is a violation with respect to the human rights and with respect to the environmental protection. So this section 2 lays down the definitions and areas on which the company has to focus. For example, from the human rights risks inside the company and the supply chain point of view, there are several areas which companies have to focus on to make sure that there is no or little violation. The areas include the child labor, forced labor, forms of slavery, disregard of workplace safety standards, disregard of right to freedom of association, discrimination against employees, denial of decent wage, human rights abuses connected with the environmental damages, and unlawful displacement of persons and violence on the part of security forces. So this is a clear indication of possible violations and where companies can easily keep them in their policies. Similarly, from the environmental protection in the company and the supply chain point of view, companies have to focus on the following areas. So manufacture of mercury added products which are clearly described in the Minamata Convention, and use of mercury compounds in the manufacturing process, and production and use of chemicals pursuant to POPs, persistent organic pollutants, with respect to the Stockholm Convention, and improper handling, collection, and storage and disposal and waste of POPs, especially import export of hazardous waste with respect to the Basel Convention. There are additional requirements too, which you can go through the regulation, but these are the major requirements. Next slide, please. So the section 3, it is the main section, I would say, which is talking about the due diligence. So once we understand the scoping and what is the violation, so one has to start working on the due diligence practices. So there are certain sections which need to be which are elaborated in the subsequent slides. So fundamentally, there are 9 requirements, which takes care of the due diligence. So to start with, the companies need to establish a risk management system. They need to designate a responsible person. They have to perform regular risk analysis. Most importantly, the company needs to have a policy statement that covering the requirements. Companies have to lay down preventive measures in its own area of business through its direct suppliers and through its direct suppliers too. They need to have a remedial action mechanism in case of any violation. They need to establish a compliant management procedure in case of any violation that has occurred. Companies also need to implement the due diligence obligation with respect to risks, even at indirect suppliers too, not only on the direct suppliers, with respect to indirect suppliers too. Most importantly, all these should be documented and reported annually and should be made available to the public, preferably on their website. Next slide. So the section 4 talks about the risk management, which is the core area of the regulation. So now we spoke about the 9 requirements in the previous slide. So we are going to talk about all the 9 requirements in depth in the coming all these slides. The first requirement is risk management. Among the 9 requirements, the companies must establish an appropriate and effective risk management system. It must include all the relevant business processes and including the stakeholders. They should have the measures that make it possible to identify and minimize human rights and environmental related risks, and to prevent and our risks or violation within the supply chain. They need to designate a responsible human rights officer. If possible, the senior management must seek information on regular basis, at least once a year, about the work of the responsible person. Companies should also consider the interests of their employees within their supply chain, and those who may otherwise be directly affected. Next slide. Now we'll talk about the next requirement called risk analysis. Once the risk management is taken in place, one has to perform the risk analysis by collecting the data. So it is written in the section 5. So companies must conduct an appropriate risk analysis to identify human rights, environmental related risk in their own business area and at their direct suppliers. So the identified human rights and environmental risk must be weighted. That means, whichever is the severity, whichever has the major severity or minor severity, accordingly it has to be prioritized. The results of the risk analysis are should be communicated internally to the relevant decision makers and the top management and the internal stakeholders, whoever is applicable. The risk analysis must be carried once in a year at least, and on demand basis it needs to be conducted whenever there is a significant change in the supply chain or mergers and acquisition that might happen. Next slide, please. So the next topic is preventive measures. So once the risk analysis is being performed, preventive action is also a parallel method. So companies must implement this in their own business area and for the direct suppliers. So this can happen from the own business area. This can happen on the implementation of by implementation of human rights strategy or procurement strategies, or purchasing practices to prevent and minimize the identified risks. So provide periodic training to the suppliers. Should also include risk-based control measures to verify compliance as per the policy. From the direct suppliers point of view, the consideration of risk in the supplier selection, and we should also have contractual assurances to comply with the human rights obligations and make sure they're enforced within the supply chain. And periodic training to the suppliers and education is very important here. And of course, a risk-based control mechanism to verify the compliance. As usual, these preventive measures must be measured for the effectiveness at least once in a year. So the reason why we are emphasizing on all these points, because these are all clearly written in the literature, especially checking the effectiveness at least annually. These are all the points which are written in the literature. Next slide. So section 7 talks about the remedial action. So far we were talking about the preventive action or preventive action. So now in case there is a violation that has happened within the supply chain or within the business premises, so how to handle it? So the key actions include the company, if the company discovers a violation in its own business area or at a direct supplier, it must, without undue delay, take appropriate remedial action to prevent and or minimize the extent of violation. If the violation has occurred at the direct supplier, which the company cannot end in the foreseeable future, it must draw up an implementation plan for ending or minimizing the violation without any delay. So the company should jointly work with the supplier to develop and implement an action plan to minimize the violation, and which is all time bound activities. And if needed, there could be a temporary suspension of the business relationship even. So the termination is also advised if the business relationship, if the violation is very serious, and even post implementation of the plan, which we feel there may not be any improvement, and in such cases, termination is the only option. But however, this is not encouraged. Again, the company should evaluate the effectiveness of the remedial action at least once in a year. Next slide, please. The section 8, which talks about the compliance procedure, that includes all the compliance procedure must be written, and they should be made publicly available to the employees, the suppliers, preferably on the website. Each person, the person who has complained, must be treated impartial and confidential. The effectiveness must be reviewed at least annually once. Again, next slide. So let's talk about indirect suppliers here. So when you take a company, you may have the control over the direct supply chain. Hence, we can implement preventive or corrective approaches since we deal with them day in, day out. However, this German law speaks about the violations by an indirect supply chain, that is the supplier of your supplier. That's called sub-supplier. So this section 9 talks about how to handle the violations that are observed in case from the indirect suppliers. So if a violation occurred, the compliance procedure should be designed in such a way that the people can report the risks and violation of an indirect supplier. For example, there is a supplier which is your supplier, and when you come to the web or reading the newspaper, you come to know that there is a sub supplier who made a violation, and you came to know that through media, that has to be immediately reported as a risk, and and you should work towards the remedy. That needs to be informed to your supplier, and you need to work on the remedy. If the company has actual indications that suggest a violation of an indirect supplier, it must carry out the risk analysis, how much risk you may have on it, and lay out appropriate preventive measures, and draw up an important implement the preventive, or minimize the minimize it. So update the policy statement if needed. So unlike the traditional supply chain due diligence act, like in the French or other existing regulations, which do not talk about the indirect supply chain, here they're also talking about the indirect supply chain. Next slide. So the section 10, the documentation and reporting obligation. This is something which is very much mandatory. The due diligence obligations must be continuously documented, and all this documentation must be kept for at least 7 years from its creation. So the companies, for the previous year, the companies must prepare an annual report within 4 months from the for the previous financial year, and it should be publicly available in the website. And what should it contain? Whether the company has identified any violations, and if so, what the company has done to fulfill the due diligence obligations, and how did the company assess the impact and effectiveness of the measures, and what are the conclusions it has drawn from the assessment for the future measures. Next slide. So now that we discussed all the 10 sections or the 9 requirements, there is one more important section, that is section 24, which talks about the penalties which made this regulation so popular and caught the eye of German companies. So when the French regulation was issued, there was not much buzz, but when the German law was issued, there is a lot of buzz and a lot of activities. Many customers are interested to know what is this, because of the penalties that it has. So any negligent violation of due diligence obligation is considered as an offense, and it is a punishable by fine. And any intentional violation can result a fine up to 800,000 euro for a natural person, or up to 8 million euro against the legal entities. In some cases, it can go up to 2% of the annual turnover too. These are some of the penalties. There are various penalties for type of severity. Next slide. So this gives a comparison matrix. So is Germany the only one to implement such kind of regulation in the EU? No. We already learned about France. So from 2017, it is in force, and 2023 onwards, Germany is going to do that. And similarly, EU is also working towards a common regulation. Similarly, Norway, Netherlands, the Dutch, Austria, and then Belgium are also working in such regulations, but those are all in the proposal state yet. You can see the reference link, which is given below. Next slide is an extension which talks about several attributes or several areas where they are linked to. So now we spoke about EU, and similarly in the rest of the world, especially United Kingdom. In the UK, the Modern Slavery Act was already introduced in 2015 to ensure transparency in the supply chain. The act requires the publication of statement setting out the steps that companies have taken to ensure the businesses are free from modern slavery, including slavery, servitude, forced and compulsory labor, and the human trafficking. The Modern Slavery Act has a global reach and applies to any corporate body with with a minimum annual turnover of 36 million pounds, including the subsidiaries, based out of UK companies, which carries business on a part of business in the United Kingdom. So the UK government has also published a statutory guidance of the reporting documents, and which sets out the expectations about the areas that the statement should cover. With respect to the United States, previous slide, please. With respect to the United States, there are several laws, especially in particular with the federal and states level. Uh, you know, so for example, Alien Tort Claims Act, California Transparency Supply Chains Act to combat human trafficking and slavery. In addition to that, conflict minerals, which is very famous, in Dodd-Frank Section 1502, conflict minerals rules in which the Stock Exchange Commission, SEC listed companies are required to review their supply chains for certain minerals if they may originate from the conflict regions, and and to take action to address any human rights related risks are found. However, there is no silver lining. So far, there is no comprehensive or a single source of US law or not even a European law that covers all the required ESG requirements, supply chain due diligence requirements, in both in the EU as well as UAS jurisdiction. So we'll have to wait and watch for a harmony to happen. Next slide. So in principle, there is there is a growing importance of ESG, that is environmental social governance. So in principle, the Germany's new supply chain due diligence GSDD Act is a part of environmental social governance standard. So GSDD has to be treated with an extra caution. The German law has to be treated with extra caution due to the hefty fines or the penalties that law imposes on the violation. So you may have already noticed that some of your customers have started asking for exhaustive ESG surveys. Again, the same problem here. Even though there are humpty number of standards which are available for ESG, they're all not using the same approach. A couple of them which we have indicated here: CDP, CDSP, GRI, SPTI, SA, SP, TFT, PRI, and WF standards. So we expect, the industry is expecting the common standard which everybody can follow, and that makes the overall process simple. But however, independent industry associations are working towards a common standard. For example, the automotive industry has already implemented SAQ. That is SAQ. The current version is for SAQ 4, which stands for Supplier Self-Assessment Questionnaire, which is something many of the automotive companies are following. That is a common ESG standard. For all these requirements, at the end, in the end, the companies have to start collecting the details from the suppliers with respect to the risk perspective view in the form of surveys or via software or a simple spreadsheet. So the crux of the information lies with the suppliers. So fundamentally, we have to get this data from the suppliers. From there we have to analyze the risk and perform the due diligence, ask the questions back, and verify or audit them, do a random sampling, and then do that analysis and record in case of any violation that is found. So during this, data gathering from suppliers directly alone is not sufficient, because it all depends on what they answer, but also as a responsible corporate company, they have to monitor the media or newspapers, or whatever media or social media, to ensure what if there is any violation that was reported in the media, and that also should be taken into consideration as a part of the risk analysis. So some of the sample survey forms that are attached for your quick reference here. And similarly, as you may have already noticed, the companies may have already noticed, in addition to the 3TG mineral traceability, some of the German companies, German OEMs have started asking for the reasonable country of origin for other minerals apart from the 3TG, cobalt, lithium, palladium, glass, mica, or magnesium, or natural rubber, rare earth. So eventually, along with 3TG conflict minerals, companies may ask for traceability of all these minerals too, check if they are originating from the high risk conflict affected areas. So we should be prepared, companies should be prepared for it. Next slide. So to summarize, when it comes to the practical implementation of the German Supply Chain Due Diligence Act, one need to check the applicability, which might be a simple step. Companies have to perform gap analysis, what is needed and where they are now. A point of contact or responsible person is required to be appointed. Companies need to have a proper revamped policy and procedures, and make them available across the organization and publish them either on the web or for the suppliers, for the suppliers and public reference. And a proper communication inside the company and to the supplier should happen periodically. We should also conduct, a company should also conduct supply trainings and a periodic review of the existing contractual terms with the suppliers, and if needed, include additional clauses, and use the digital technology, that means software for the supplier survey or 360-degree survey for the risk monitoring on the suppliers, which is the crux of the entire problem, which that gives the a solution. And need to have a proper compliant mechanism. Most importantly, the documentation, and they especially to be prepared to be with requires to be reported them annually if the regulation is applicable for the companies. Last but not the least, please be prepared to answer Humpty number of questions from your customers on the ESG requests, and keep the customer requirements also in mind while drafting your policies. Next slide. Over to Pavitra.
It's time for a quick vote.
Thank you. Next slide. API also has additional softwares apart from, we are working on the ESG module currently. We don't have it ready yet. We will be launching it very shortly. That also covers the German due diligence requirements. But we have the conflict minerals modules for 3TG, cobalt, mica, and we also have the IMDS, which is unique uh, software that nobody else has, that reduces the effort at least by 50%. For the non-automotive sectors, we have a software called Green Check, which takes care of reach, rows, Prop 65, TASCA, and other requirements. We also have a special software called Volatile Organic Compliance, which takes care of the companies where they're dealing with liquid and gaseous products.
And there will be a survey at the end. We would kindly ask you to spend a couple of minutes, which will help us to improve our future webinars. Now, we will go through some of the questions and answers. So, over to Sri.
Thank you, Rohita. So we have 4 minutes left. I do have two questions. When you said are there any standards for the minimum wages? Yeah, the law does not lay down any global minimum wages as per the International Labour Organization convention, which requires a decent wages. So the desirable wage levels may vary from country to country and are guided by the respective economic situation. But however, there are no minimum wages mentioned here. And another question is, so what must a company do in case of a violation that is found from indirect supplier? That's a good question. Unlike other regulations, this particular regulation is also talking about the indirect supplier violation by indirect supplier violation. In such cases, immediately conduct a risk analysis, report to the ombudsman or the reporting officer, uh, conduct a risk analysis and implement the strategy to minimize and avoid the problem. Discuss with your direct supplier where that indirect supplier is associated if possible, and firmly establish a prevention measure and work on a plan B, to avoid committing the violation. Yeah, I have one more question that is coming up. Will German companies be held liable for what the suppliers do at abroad? Yeah, unfortunately, I wouldn't say yes here. The law talks about the supply chain here. And the suppliers can be anywhere present across the globe. So companies are not expected to guarantee that they will remediate all the risks in the supply chain globally. So what the regulation says is you will have to exercise the due diligence. That means have a risk plan, risk mitigation plan, and perform the risk analysis. If you find any risk, work on the prevention method or correction method and document it. That's what the law is requiring it. So the law does not say the penalty if your supplier does a violation. All that law says is if you leave it, even if you know, then there is a violation. So that's what it covers all in the reporting requirements. Yeah, I think we're all on time. Over to Pavitra.
Thank you very much, Sri, for your insights on ESG's implementation. Thank you everyone for attending our today's webinar. For those who need to reach us, please write to compliance@apaengineering.com. Thank you once again. Thank you all.